On that day, I was in a judicial custody in Trivedi jail. Thereafter, my lords, empty vehicle that was parked in Goa collected the key from the home, threatened my wife and collected the key and they brought it.
If it is not released, we will state and direct the magistrate to consider it, reconsider the whole thing. Empty vehicle ತಗೊಂಬಂದಿರೋದು.
Correct. This vehicle was used.
Car ಅಲ್ಲಿ 10,000 liters ಅಲ್ಲಿ.
This vehicle was used to procure goods from Goa to pack the.
No. Reason may be anything. That is subject matter of crime. Whether it is releasable or not, let the magistrate decide it. Why does he make it over to the deputy commissioner now?
Petitioner, on 5th September 2020.
The order of magistrate court is correct. The PF which was originally given to magistrate court was transferred to deputy commissioner because this is the proceedings under Excise Act. Let them go before the deputy commissioner and get it released.
You want release of the vehicle?
10,000 liters of
liquor.
Plus, it is literally a factory.
I am not asking for the other material sheet from some other. My vehicle is already questioning. I will.
That you can seek before the deputy commissioner.
No,
why?
My instructions are that, my lord. The deputy commissioner of Excise has not received the material, the goods.
I'll place the
I will pass an order.
No,
now he
I will submit.
received and ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ ಅಲ್ಲಿ.
I will submit, my lord. I will submit. My lord, may be pleased to, my lord. I am little slow in this.
No, that can't be. ಹೇಳಿ.
My lord, on 5th September 2024, the case has been registered, showing my name is Ravi. And as on that day, for the offences under Excise Act, that in particular place, they were able to find certain contraband articles. On that day, I was in a judicial custody in Trivedi jail. Yes. Thereafter, my lords, the vehicle, empty vehicle that was parked in Goa, the Goa registered vehicle, Goa, it was made for the purpose of my son, who is 75% neurological disabled, it's called autism. It was made for that his use and it was kept in a parking place. And from that particular place, it was seized several days thereafter. Even on the date of the seizure also, I was not available because I was in a judicial custody. Collected the key from the home, threatened my wife and collected the key and they brought it. Be that as it may. It is an offence punishable under Karnataka Excise Act. Section 43, I am very well how the section 43 came to be inserted. Otherwise, it is 451 of CrPC in normal course. After noticing that, the government experiencing it that the 451 is a very easy method for the culprits, and they amended like forest offence. Now I may permitted to read section 43. My lords,
Madam.
Notwithstanding Karnataka Excise Act, notwithstanding anything contained in this act, my lords, they are so careless. I will produce the vehicle photograph also now, my lord, how these police officers, notwithstanding anything contained in this act or any other law for the time being in force, where anything liable for confiscation under section 43 is seized or detained under the provisions of this act, the officer seizing and detaining such property shall, without any reasonable delay, produce the same before the officer not below the rank of superintendent of excise authorized by the government in this behalf. On production of then once it is produced without delay, it comes within the purview of the authorized officer appointed under the Karnataka Excise Act. My lord, what happened was that, my lord, after lapse of considerable length of time and after the charge sheet is filed, I came this honorable court, and after he was released from Trivedi jail, till then he could not do except that he went before the communicated through the prison officer for release of the property. I came before this honorable court questioning the charge sheet in WP number 27261 of 2025, page number 64. My lord, the honorable court noticed that the charge sheet has already been filed and that it is the proceedings can be completed. My lord, my prayer for release of the vehicle, my lord, may kindly see page number 68. Since it is submitted that, para 7, vehicle seized and produced before the learned magistrate, they did not produce before the authorized officer.
Hmm.
It is open for the petitioner to file an appropriate application, if not already filed,
Hmm.
before the learned magistrate.
Hmm.
If any application is filed or pending, the learned magistrate shall pass an appropriate order expeditiously,
Hmm.
as far as possible, within a period of 15 days
Hmm.
from the date of this. So, my lords, were of the opinion that
Hmm.
though section 43A was available,
Hmm.
since it was not invoked,
Hmm.
and 451 CrPC or the equivalent under the BNSS is available. So accordingly, in terms of the liberty given by this honorable court,
You filed an application.
filed an application before the learned magistrate.
What happened to that?
That application was opposed. The learned the public prosecutor available as on that day of court could have considered that, yes, I have by erroneous way, he makes an, I must submit that before the magistrate, application was filed by the police officer seeking permission to retain. He seizes an application vehicle triable by the magistrate for the offence under Karnataka Excise Act. Then he should have been aware of section 43A also. Instead of that, he makes an application before the learned magistrate and seeks custody of the vehicle. Now, my lord, on my application, page number 85, annexure G. Then he files objection after my application was filed in terms of the direction. My lord, he files objection that page number 86, para 5, ಮುಂದುವರಿದು ಕಲಂ 43 ಕರ್ನಾಟಕ ಅಬಕಾರಿಕ ಯಾವುದೇ ವ್ಯಕ್ತಿಯ ಸದರಿ ಕಾಯ್ದೆಯನ್ನು ಅಪರಾಧ ಮಾಡಿದಲ್ಲಿ ಸದರಿ ಅಪಕಾರ ಎಲ್ಲಾ ವಸ್ತುಗಳನ್ನು ಅಮಾನತುಪಡಿಸಿಕೊಂಡು ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟುಗೋಲು ಹಾಕುವುದು ಅವಶ್ಯವಾಗಿರುತ್ತದೆ. He realizes, this police officer, trained police officer, realizes after over an year, after the vehicle is destroyed, that he is not the person, it is the authorized officer. The magistrate is not the one authority, jurisdiction, but an authorized officer. My respectful submission is that, my lords, in spite of section 43A, so long it is not reported to the authorized officer or seized goods is
ಈಗ
not
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದಾರಾ?
ಮಾಡಕ್ಕೆ learned, I have questioned that order of the learned magistrate.
Hmm.
The learned magistrate, after receiving the objection of the prosecution, my
Has
lord,
transferred it to deputy commissioner.
he said you make over to the deputy commissioner. Then, my lord, I have verified from the excise also. My lord, it is the responsibility of the authority. My information is that, my lord, the deputy commissioner of excise did not take the vehicle because the condition may kindly be seen. Kindly be seen. They have kept it in open ground where the garbage which is required to be removed by Greater Bangalore Authority is dumped. This is the condition, my lord. We should, if you see Bangalore city anywhere, my lord,
No, that is there.
yes, they keep almost all footpaths are with auto rickshaw. There is nothing wrong.
No, vehicle condition bidi paralla. Now, if it was before the magistrate only,
It was
PF
before
was
the
drawn before the magistrate. Where is the question of making it over once it is already done? Whether he should release it or not release it?
That I have produced the order sheet also.
Page 95, my lord.
If it is not released, we will state and direct the magistrate to consider it, reconsider the whole thing.
My lord may be pleased to direct, but otherwise what happens is, may
No,
not
the
make
only problem, my lord, it is not a small quantity. The entire factory has been
No,
used.
no,
and
no. That
I've
is
been
not, I'm
told
not
that this
concerned.
vehicle-
My
and I've been
vehicle,
told-
ಅಲ್ಲ ಇದು ಎಂಟಿ ವೆಹಿಕಲ್ ತಗೊಂಡ್ಬಂದಿರೋದು.
Correct, that this vehicle was used.
ಕಾರಲ್ಲಿ 10,000 ಲೀಟರ್ಸ್
No, no,
ಅಲ್ಲಿ.
no, no. This vehicle was used to procure goods from Goa to pack the
No.
Reason may be anything. That is subject matter of crime. Whether it is releasable or not, let the magistrate decide it. Why does he make it over to the deputy commissioner now? ಎದುರ್ಕೊಂಡ್ಬಿಟ್ಟು 43 ತೋರಿಸಿದ ತಕ್ಷಣ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ನಮ್ ಮಾಡಿದ I leave it to your lordship.
my lord, my humble submission would be, my lord, exercise jurisdiction. The 43A, my lord, was very stringent.
So
This
that
honorable.
now I will direct the magistrate to consider the application of 451, what you have filed on its merit. And if the vehicle is not transferred, should not be made over, even if it is not and today made over, it shall not be made over. I will fix a time limit for him to pass orders.
The difficulty, only this consideration, my lord, this, even before this honorable court, my lord's board is so heavy that 27th November I came.
November ಏನು?
2025.
ಫೈಲ್ ಮಾಡಿದ್ದ? ಏನ್?
2025. And immediately on that, my lord, the subsequent and the pathetic condition I can
No, ಅದಕ್ಕೆ
submit.
I will,
One pathetic condition I may be permitted, we have experienced it. The boy is so, my lord, in a condition,
no problem.
visited my office. I had to repair the closet of the washroom because it was totally broken because it was allowed to be used by him in my office.
All
That
right.
is the condition. And my lord, these people, my lord, and taking, he is no way connected to this. His name was not as a
No,
player.
we are on a vehicle, sir. I will direct the court to pass orders in 15
And
days.
what I would try to convince my lord is that, my lord, if that direction is issued, my lord, for the police, because in fact, my submission would have been very more wider, because I have seen this type of things.
No, correct. In your experience, you have seen.
And to repair itself, it will be half the vehicle cost.
That we'll see.
Of course,
petitioner-
what I submit is, my lord, if my lords may be pleased to direct them to release my lord.
No, that will be, because let them do it in a, I cannot take their jurisdiction and do it. We'll set this order aside, direct.
That asylum officer also has not issued notice to me. If it is made out to him,
It is made over andre, I will, if it is not made over as on date.
I say that I have given a letter to the asylum officer.
I placed
My
the
instructions
communication.
are that he did not take it. Because these officers come across with the
19th November ಆಗಿರೋದು ಏನಾಗಿದೆ ಈಗ ಮತ್ತೆ?
Hey, your lordship may
ಈಗ
say-
ನಿಮ್ಮ ಹತ್ರ ನಿಮ್ಮ ಇಲ್ಲಿಗೆ ಬಂದು ಎಕ್ಸೈಸ್ ಬಂದಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, the excise commissioner has to
Excise
release it.
ಆಗಲಿ,
If
police
the file-
station ಮುಂದೆ
ಅಲ್ಲ, if it is,
Confiscate
see,
it or-
I will give both the options.
Yes.
In case it is already transferred, you will fill an application before the Deputy Commissioner of Excise, who will consider it in 15 days and pass orders. Magistrate goes same thing.
Yes.
difficulty will be I have, because these officers, excise so far as concerned, we have verified also.
ಅಲ್ಲ, ಅದಕ್ಕೆ both the options. Whatever you, if this is not there, that will be there.
The Honorable Magistrate may be may not, because it's the
ಅಲ್ಲಿ
type of-
ಎಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ರೆ ಮತ್ತೆ ಯಾಕೆ ಈಗ ತರಿಸ್ಕೊಂಡು?
and the seizure and production of the property is only for
Is by the,
purpose of
no problem.
identification in
No
evidence.
problem at all. If by this order, because 3 months have elapsed, if it is gone to the custody of the Deputy Commissioner of Excise, we'll direct him to do it. If it is in the, if it is not yet gone, I will direct it to.
43A says forthwith, immediately on, normally. it's 24
ಅಲ್ಲಿದ್ರೆ
hours.
ಅಲ್ಲೇ ಹಾಕಿ ಅಷ್ಟೇ.
Because again, what happens is,
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಮುಂದೆನೆ ಹಾಕಿ.
rely upon two judgments of this honorable court, that bank guarantee is not necessary.
ಅಲ್ಲ, ಅದಾಯ್ತು, ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿ ಅದು.
Grateful.
Now, after hearing these intense courtroom exchanges, here's what the case really boils down to. This case centers on a jurisdictional clash over releasing a seized vehicle linked to an excise offence involving nearly 10,000 litres of liquor. The petitioner claims he was in judicial custody during the seizure, had no role, and that the vehicle meant for his 75% disabled son was taken from parking after police pressured his wife and is now deteriorating. The legal issue is whether authority lies with excise officials under the Karnataka Excise Act or the magistrate under section 451 CrPC. The confusion grew as police approached the wrong forum and later challenged jurisdiction. The court, noting the seriousness, avoided direct release and ruled that if the vehicle is with excise authority, the petitioner must approach them. Otherwise, the magistrate must decide, both within 15 days. A classic case where law, procedure and ground reality collide, and the final outcome now rests on how swiftly the system corrects itself.